Good afternoon, everyone. Thank you to Dr. Kennedy and Dr. Caoimhe for organising this series of seminars, and to Dr. Brian Barry for that introduction. My name is Caoimhe Kiernan, and I'm a PhD candidate in TU Dublin under the supervision of Dr. Barry. My PhD is looking at the impact of the female judge in Ireland. Today, I'm going to be talking to you about a comparative analysis of the composition of the bodies responsible for investigating complaints against the judiciary. Specifically, I'll be talking to you about the committees responsible for investigating complaints of judicial misconduct in Ireland, New Zealand, and England and Wales. So firstly, what is the purpose of judicial conduct oversight committees? First of all, we have to look at the protection of judicial independence. So it's essential to consider how a disciplinary regime may affect or threaten the notion of judicial independence. Secondly, looking at protection of public confidence in the judiciary. Ireland currently ranks 12th out of 140 countries for judicial independence in the Global Competitiveness Report, and it's important to protect that public confidence. Finally, talking about judicial accountability and fairness. This is linked to public confidence, but it is a little bit separate. Casey noted what might be forgiven in the ordinary citizen may not necessarily be pardoned in the judge, and the judicial oversight committees need to be cognizant of that fact. Turning to the judicial discipline process in England and Wales, they have a Judicial Conduct Investigations Office, so it's also known as the JCIO. It has 15 staff members who are all civil servants, and this is legislated for under the Judicial Discipline Prescribed Procedures Regulations 2014. As part of their judicial discipline process, they also have the Lord Chancellor and the Lord Chief Justice who are responsible for judicial discipline in England and Wales. The Lord Chancellor is a senior cabinet minister, and the Lord Chief Justice is head of the judiciary of England and Wales and is president of the courts of England and Wales. So they themselves are a judicial office holder. So the judicial discipline process in England and Wales is very transparent on the face of it. And the JCIO publish all their procedures online on their website. They're an independent statutory body. They initially investigate all the complaints. Most complaints are actually dismissed at this initial stage. So firstly, the complaint is made to the JCIO by a member of the public or a solicitor, a barrister. It's referred to the JCIO by a leadership judge, or an office holder self-reports a complaint. The JCIO will make one of two findings at this initial stage. They'll find that it's outside their remit and can be dismissed straight away. In that instance, they inform the complainant and the complaint is rejected or dismissed. Otherwise, the complaint is assessed as requiring further consideration. It's sent to the office holder themselves, so the person who the complaint is about is informed of this, and comments are requested on the complaint if required, and then the JCIO gathers any further information needed for further consideration. Once they gather that further information, one of two things happens. They either consider the complaint can now be dismissed, or they consider that the complaint cannot be dismissed at this stage. They invite the office holder to comment further, and they refer it to a nominated judge. So a nominated judge is appointed by the Lord Chief Justice to investigate matters like complaints by the JCIO. Once this happens, the complaint and the related info are referred to the nominated judge. If the nominated judge finds misconduct at this stage, they must recommend a sanction for that conduct. The JCIO sends the nominated judge's report to the office holder, so they get to comment on it. And then once the office holder comments, the JCIO send their report and the office holder's comment to the Lord Chief Justice and Lord Chancellor for a decision. So while the nominated judge can make a recommendation on the sanction, the Lord Chief Justice and the Lord Chancellor are the individuals responsible for ultimately deciding on whether a sanction is warranted or not. They will then write to the office holder with the decision, and the JCIO will inform the complainant. So if the complaint is sufficiently serious or complex, or if removal is the recommended sanction by the nominated judge, the complaint is then referred to an investigating judge or to a 4-person disciplinary panel, which consists of 2 judicial office holders or 2 laypersons. Sanctions available under this judicial discipline process include formal advice, formal warnings, reprimands, or removal from office. And this is all detailed in the Constitutional Reform Act 2005, and that's under section 108.3. The JCIO is also, while it is in and of itself an independent statutory body, it's overseen by the Judicial Appointments and Conduct Ombudsman, who are responsible for reviewing how complaints of judicial conduct have been handled. So judicial disciplinary process is conducted by a combination of judicial office holders, elected members of parliament, and laypersons. Moving on to judicial discipline in New Zealand, there are 4 bodies of individuals responsible for this process. So we have the Office of the Judicial Conduct Commissioner, which consists of the Commissioner and the Deputy Commissioner, and they are both appointed by the Governor-General of New Zealand. This is upon a recommendation by the Attorney-General, who also consults the Chief Justice of the Judiciary on these appointments. The Attorney-General is also involved in the judicial discipline process. They recommend they follow through in the actions recommended by the Judicial Conduct Commissioners. Heads of the bench of each of the courts in New Zealand are responsible for dealing with minor complaints from the Judicial Conduct Commissioner, and the House of Representatives are involved when they recommend a sanctions removal of a judge. So the process in and of itself is relatively straightforward, and again, quite transparent. It's on their website. It's laid down in legislation. Once the commissioner makes their recommendation following the initial investigation of the complaint, their role is finished. So at this stage, the commissioner receives a written complaint about a judge. It acknowledges receipt of the complaint. It considers and undertakes an initial investigation of the complaint. And there's 4 outcomes that can happen. So it can take no further action on the complaint. It can dismiss the complaint. It can refer the complaint to the appropriate head of bench. So the commissioner has the option of referring the complaint to the head of bench and saying, this is a minor complaint. We found that it has merit. We now would like you to deal with it. And the head of bench then takes forward an informal process of dealing with the complaint with the individual involved. Finally, the commissioner can conclude that an inquiry is necessary and recommends to the Attorney-General that a judicial conduct panel is appointed. Moving on from that, the Judicial Conduct Panel conducts a hearing. They report to the Attorney-General, and the report that they send to the Attorney-General has to include findings of fact, opinion on whether the conduct warrants consideration of removal, and reasons for the decision. So the Attorney-General will then act on that recommendation from the Judicial Conduct Panel. Obviously, there's 2 different methods of judicial removal in New Zealand. For associate judges and other judges, the Attorney-General advises the Governor-General, and the Governor-General removes the judge from office. In the case of High Court, Court of Appeal, Supreme Court and Employment Court judges, the Attorney-General has to begin a motion to Parliament to address the Governor-General seeking removal. So the House of Representatives gets involved in that instance. And then from that motion, the Governor-General will remove the judge from office. So the only formal sanction available in New Zealand for judges is removal from office. There's only been 2 recommendations since 2005 for a judicial conduct panel, and neither of those conduct panels actually completed. In the midst of one of the panels, the judge at the center of the panel actually resigned. So the judicial conduct panel only conducts investigations into currently sitting judges and not judges that have been retired or have resigned. So that judicial conduct panel ceased. And then the most recent case, judicial conduct panel was recommended, but the head of bench of the office holder involved stepped in and recommended that the office holder step down for a certain period of time to undergo judicial retraining. And therefore, the Attorney-General found that the judicial conduct panel was not required in that instance. So there's lay persons running the initial complaints process. So those first steps before a complaint is given to the Attorney-General. And at that stage, the majority of complaints are dismissed. The judicial and the executive action required following that initial recommendation is only on a very small minority of complaints. It's difficult to ensure that the heads of bench deal with the complaints appropriately if they're referred to the heads of bench, as the complaints process is voluntary because judges are by law immune from direct discipline to ensure that justice is administered impartially in New Zealand. And there's poor public confidence in the judicial disciplinary system as a result of this. Over 3,200 complaints have been made since 2005 about judges in New Zealand, and no judge has been formally disciplined for their conduct since 2005, since the introduction of the system. Moving on to the judicial disciplinary system in Ireland, as Dr. Caoimhe has already gone through the Judicial Conduct Committee and the Judicial Council Act, I will be very, very brief in going through this. So the Judicial Conduct Committee was established by the Judicial Council Act 2019. It was recommended for many, many years prior to this. The function of the Judicial Conduct Committee is stated as follows: to promote and maintain high standards of conduct among judges, having regard to the principles of judicial conduct, requiring judges to uphold and exemplify judicial independence, impartiality, integrity, propriety, competence and diligence, and to ensure equality of treatment to all persons before the courts. Now, those are very lofty ideals, but what does that actually mean in practice? So the functions laid out by the Judicial Council Act 2019 state that the Judicial Conduct Committee are to investigate complaints, refer them for resolution by informal means, or undertake investigations into the conduct of individual judges. They're to safeguard the administration of justice. They're to draft and publish guidelines for resolving complaints by informal means. They're to draft and submit judicial conduct and ethic guidelines to the board, which they've completed, and they've to provide such advice and recommendations to an individual judge or to judges generally on judicial conduct and ethics as they see fit. So the Judicial Conduct Committee will comprise of 13 members, including the Chief Justice, who will act as the chairperson, President of the Court of Appeal, the President of the High Court, the President of the Circuit Court, President of the District Court, 3 elected members from ordinary judges of the Supreme Court, the Court of Appeal, the High Court, the Circuit Court, and the judges of the District Court, other than the President. And also 5 lay individuals. And these lay individuals will be appointed by the government with specialist knowledge as set out in the Judicial Council Act, Section 45. So it's envisioned that this committee will be established by the 3rd quarter of 2022. It's going to be a mixture of both lay and judicial members, as I've just outlined. Similar to New Zealand, Ireland currently has only one sanction for judicial misconduct, and that's removal. It's unclear what this formal resolution process will look like. We will hear more hopefully in the coming weeks and months, based on the guidelines drafted by the Judicial Conduct Committee, which are currently under review by the Board of the Judicial Council. Without formal disciplinary procedures in place, public controversies can erupt and have no formal or obvious solution. And that was the case with Mr. Justice Seamus Wolfe and with Judge O'Connor recently. Looking at it comparatively, in New Zealand, as I've stated, there's removal is the only formal sanction available. The individuals involved in judicial discipline are the Commissioner and the Deputy Commissioner, who are non-judicial office holders, the Attorney General, who's a non-judicial office holder and an elected senior cabinet member, heads of the bench, who are all judicial office holders, so they're the heads of the bench of the courts of New Zealand, and the Judicial Conduct Panel, and that involves 2 judicial office holders and 2 laypersons. In England and Wales, the JCIO is 15 at the moment, 15 civil servants. The Lord Chief Justice is a judicial office holder. The Lord Chancellor is an elected senior cabinet member. The nominated and investigating judges are judicial office holders, and the disciplinary panels are 2 judicial office holders and 2 laypersons. It's envisioned in Ireland that we will have a 13-member Judicial Conduct Committee, which will consist of 8 judicial office holders and 5 laypersons. Obviously, from a comparative perspective, you can see that in New Zealand and in England and Wales, by the very nature of their processes, there are multiple offices and multiple individuals involved. In Ireland, we shall see how the judicial conduct process works its way out, including any informal processes that are established. Currently, it stands at the 13-member Judicial Conduct Committee that is a mixture of judicial office holders and laypersons. From the international norms of other common law countries, we can see that having non-judicial office holders and having laypersons involved in the judicial discipline has been very important. So what would an ideal Judicial Conduct Oversight Committee look like? Firstly, they would have independence, so they would have institutional independence as opposed to individual independence. They would balance that institutional independence with the protection of the judicial independence, like we talked about at the start of this presentation, and the separation of powers, which was also talked about at the start of the presentation. The ideal Judicial Conduct Oversight Committee would be accountable to both the public for dealing with complaints and to the judiciary for dealing with complaints. They would be impartial to avoid claims of bias from the public or the judiciary. They would be fair to both the complainant and the judicial office holder, and they would be transparent. They would conduct investigations in as transparent a manner as possible. I am unsure if all of these ideals are practical, and from looking at the New Zealand judicial discipline process and the judicial discipline process in England and Wales, I don't know if they are possible in an Irish context, but I'm very hopeful. I'm very hopeful to see how the Judicial Conduct Committee implements their informal resolution process, and also how the Judicial Conduct Committee is going to work in practice. Will all 13 members sit on all investigations, or will there be subgroups and subcommittees? I think that's just going to be something that's going to have to be worked out in their policies and procedures down the line. So that is the end of my presentation. Thank you so much for your attention, and I really appreciate any questions or any comments that anybody has. Thank you very much.